Chris Farfoy.
Thank you very much, Mr Speaker, for the opportunity to speak to the Corrections Amendment Bill. I'd like to acknowledge the Law and Order Select Committee, of which Mr McKelvey is on. I think while we have some fundamental problems with the bill, the committee on the whole worked quite well together to look at some of the issues that are contained within the bill. With some serious things that are contained within here. The strip search change in regime. We actually took a trip to Remutuka Prison, which in terms of our ability to ask inmates and corrections officers some pretty probing questions, sorry to use a pun. We had the opportunity to speak to them about some of the practicalities of some of these things that this bill will introduce. So I just did want to acknowledge some of the Law and Order Select Committee members who have traversed this bill during the Select Committee stage. As Charles Chevelle, our corrections spokesperson, said in his contribution to the bill, we are opposing this on 3 grounds. The first being that we have a fundamental ideological problem with the National Party opening up the corrections part of its responsibilities in this government to private management. We don't believe that there should be a profit motive at play when we're talking about the incarceration and rehabilitation of people who transgress and then find themselves locked up. The second issue that we had an issue with was around the strip searching and the change in regime. At the moment, there are 2 regimes for inmates. One is what you will call a standard regime, and the second one is, the Honourable Phil Goff mentioned earlier in the debate, is one where there's much more detailed inspection with the use of mirrors and lights and the lifting of certain body parts. And as Mr Goff said in his contribution, there are a number of corrections officers that came to us as part of the union affiliation to talk about their concerns about moving from what I call the standard strip search to the more evasive strip search. And of course then there's the third issue that we had that Charles Chevelle pointed out, and that is the changes that the National Party is looking at by way of supplementary order paper to try and make good the legislation around the banning of smoking within... No, that's right. There was no legislation to ban the use of cigarettes and tobacco within our prisons. Something that this party supports wholeheartedly. We want to make sure that for the safety of the inmates and their health, and also let's not forget the corrections officers. They also deserve to work in a smoke-free environment. That there's legislation in place to make sure that that can happen. But unfortunately, the warning that the Labor Party gave to Judith Collins at the time when that primary legislation went through about the fact that we don't think this will be covered under your legislation wasn't heeded. Someone took the government to court, that person won, and now the government finds itself in the odd position of bringing in a supplementary order paper to try and retrospectively change the law to bring about what we agree with, but what we warned the government said wouldn't work in terms of the legislation that it brought through, rushed through, and now Anne Tolley has to clean up the mess that her colleague Judith Collins has created. But going back to my first point, Mr Speaker, and that is around our fundamental ideological idea of making sure that it is the role of government to incarcerate and rehabilitate prisoners. We believe it is a core role of government, just like we have our Defence Force and our Police Force, that in the area of incarceration you shouldn't introduce a profit-making motive into that sphere. We believe it's the role of the government not to only incarcerate but also to rehabilitate in the long-term interests of the community, to make sure that there is less recidivism out there, to make sure that the public is safe, that it's our job as a government taking an active role, a hands-on role in that sphere, to make sure that prisoners who are locked up are rehabilitated and made sure that when I put out there, it's the responsibility and the role of government to make sure that they are rehabilitated as much as they can. Also, in terms of opening that sphere up to private business, takes away some of the responsibilities that ministers have in terms of answering questions when something goes wrong at, say, a privately run prison. And we've seen on a number of occasions Serco, who run a prison currently in Auckland where things have gone wrong. We've had 3 improper inmate releases, 3 wrongful detentions, 1 escapee, and a 72% failure rate to get inmate plans up and running. And, Mr. Speaker, that is one of the reasons, in terms of private management of prisons, while we are fundamentally opposed, that responsibility needs to be taken back, and if questions need to be asked about, the improper release of inmates or wrongful detentions, those questions need to be shepherded back to the Minister in charge of corrections, not necessarily someone who's, paid, contracted by corrections to run a private prison. That responsibility has to come back to a minister in this House. The second point I wanted to make, Mr. Speaker, is also around that, and I think Mr. McKelvey mentioned that some of the contributions in this debate weren't necessarily accurate in the reflection of what happened at the in terms of submissions during the select committee process, but let's look at what others think and who think along similar lines to us. Rethinking Crime and Punishment came along and gave their testimony to the select committee, and it says here on page 13 of their submission that the incarceration of citizens, their treatment within prison and rehabilitation throughout a prison sentence is, in our view, a primary function of government. Rethinking Crime is concerned that by giving these powers to private contractors, the government is opening the door for misuse of power and corruption, as the checks and balances that apply to government departments may not be passed through to private entities. Examples of such behaviour have been evidenced by private corporations in the United States. Now, Mr. Speaker, if Mr. McKelvey was worried about a misrepresentation of some of the views that were put forward at the Select Committee, that's verbatim from Rethinking Crime and Punishment. There's also some concern from the Salvation Army within their submission. They said in their submission that they were also concerned about the business case around private management of prisons. They said, and again, I don't want to misrepresent them, so I'll read them verbatim. These new private prisons also somewhat confusingly go against recent forecasting done by the Ministry of Justice that estimate prison numbers of about 8,200, whereas the Department of Corrections is forecasting prison numbers at over 10,300. Which of these forecasts is correct? So we've got real question marks around the business case that this government is using to justify private management of prisons. Now, the government says it's using private management of prisons to save Kiwis money. Well, when the Salvation Army, Mr. Speaker, when the Salvation Army is pointing at a rather big gaping hole around the business case of private management of prisons, I think some serious questions need to be asked. Mr. Speaker, also around the strip search regime and the change of that, the Ombudsman of all officers came and made a couple of submissions, I believe, and verbatim for them, for the benefit of Mr. McKelvey, in a submission that they made on the 15th of August, they said that they are expressing strong concerns about the amendment of the section of the Act which diminishes the safeguards against prisoners being strip searched unnecessarily or inappropriately, and also removes the less intrusive type of strip search. We have previously stated that existing requirements for strip searches provide a very good balance between the rights of the department to manage its prisoners and the rights of prisoners to not be subjected to unreasonable searches. In our view, they do not need to be changed. So there you have it, Mr. Speaker. The Ombudsman, in terms of changing the regime around the strip searches, agreed with us that we didn't need to go from the two regimes to the one regime, with the one that the government prefers being much more evasive. And of course, they weren't a lone voice. The New Zealand Law Society also said that the current legislative regime regarding strip searches is effective and provides a sound balance between the need for prison security and the requirement not to unnecessarily demean and humiliate prisoners. So, for Mr McKelvey's benefit, there hasn't been any misrepresentation of any submissions in my speech. It's all been verbatim from the submissions from the people who gave the evidence to the Select Committee. And I think they are fair and reasonable concerns about some of the things that this government wants to do within this bill. We are completely and utterly opposed to private management of prisons. We have serious concerns about the regime change and strip searches, and of course then you've got the shonky work they've done around the smoking in prisons.
Alfred Nairn.